What's cracking, everybody? What's cracking? Welcome back to the channel. New video. Today we're going to be reacting to, or I'm going to be reacting to Dumb Down Law. Great channel. This guy's a practicing attorney. He does a lot of stuff regarding the cases against Wes Watson. This video right here will be in regards to the civil case, the lawsuit that was filed by the 7-foot monster. I believe at the end of this video, he's going to also talk about Larry Wheels. I've never done any, I don't think I've ever done anything on Larry Wheels. If you guys would like me to, let me know in the comments. But that said, let's see what the attorney has to say and what Wes Watson is looking at in regards to the lawsuit.
All right, everybody. I hope everyone's doing all right. Today we got an actual pretty interesting update, notable in Wes Watson's civil case. And I think you'll want to stick through till the end of this video for a special treat regarding the Larry Wheels lawsuit against his former friend and business partner, Daniel Ryjov. I'm sure a lot of you have heard about that a bit, either from John Bravo or elsewhere, but just stay tuned. All right, back to Wes Watson. All right, so what do we have today? We have an order from the judge denying the summary judgment request made by Elevation Fitness.
So Elevation Fitness already tried to make a move saying that they're not liable for what happened, for whatever the argument was. And the judge said, nope. Order denying defendant's amended motion for summary judgment. The judge said, nope, you're riding with Wes.
Now, what we'll see here is that the Miami-Dade judge has officially denied this summary judgment. And the language in this order, which we'll have attached, is actually pretty significant and creates a big problem for Wes moving forward. Oof. So here, it's not just the case of the judge saying, we'll let a jury figure it out. No, the judge here specifically identifies multiple factual disputes involving alleged prior violence, alleged gym knowledge, alleged fight challenges, and whether or not this entire altercation was foreseeable.
And, you know, Elevation Fitness has to be very upset with Wes Watson. What he's talking about right there, obviously we know, is the stuff that he was doing online. Here's the address, here's where I am, pull up, and if you want, I'll go outside. I mean, we know all the stuff he was saying, right? And it's obvious that I would say that the plaintiff's attorneys got some of that admitted. Some of that footage admitted, and the judge saw it, and that's why the judge ruled the way that the judge did. I don't know if it's a male or female, so I'm just referring to the person as the judge, right? But this is Wes Watson's cooked on this. I mean, he's once a jury sees, and you know, you guys, you know that the plaintiff's attorneys definitely, because it's still up on Wes's channel. You know, the plaintiff's attorneys, they screen recorded, they have it in evidence the day after this incident when Wes was bragging. Not a scratch on him, he said.
So in lawyer terms, that means there is enough evidence here that I'm definitely not throwing this case out. And when you read the actual wording of the order, it becomes very clear why this is dangerous for the defense. Not just Elevation Fitness, who's the party that filed for summary judgment. Okay, so let's break it down. So what happened? I think to explain what happened, first we need to explain exactly what a motion for summary judgment is. Okay, so a motion for summary judgment is basically the legal equivalent of telling the court that, judge, listen, even if you assume the other side's fact are true they still lose as a matter of law. So oftentimes we'll see this with matters that are past the statute of limitation. So, one side is basically saying, take everything as gospel that they just said. It doesn't matter. Even as law, they still can't prevail. And again, here it's essentially asking the judge to cancel the trial, throw specific charges out, or the whole case before it even happens.
Again, this gym has to be very upset at Wes, but it would be hard to imagine that nobody at that gym was aware of Wes's invitations, right? I mean, the guy's pulling up in Bugattis and all these cars, and he's bringing all these other guys. They're filming. Somebody there had to have been like, "Hey, what's going on with you? Like, are you a star?" You know how people are nowadays, right? They see a camera, they're gonna ask a question. And Wes said, "I'm the most famous on the internet," like he does. And they looked him up and said, "Wow, this guy, celebrity, comes to our gym." That's where that right there would have to be proven, of course, but obviously the judge feels like Elevation Fitness. Let me make sure. Yes, Elevation Fitness was aware. Something was submitted in court that got the judge, after reviewing the evidence, to feel like, nah, you knew.
And Elevation Fitness and their partner company, Elevation Fitness Holdings, that's exactly what they filed. They wanted out of this lawsuit before the trial. And obviously the court here said no. So we're going to go through a little bit line by line as to exactly what this document is, what it says, and what's the significance. Okay, so we see that it says order denying defendants amended motion for summary judgment. So obviously just by that title alone, you already know who lost this round. Now we're going to get into what I find is probably the most important part of this actual order.
Yes, let's get right to that.
It's sort of where things get interesting because judges, are usually extremely careful with their wording. They don't casually list factual disputes unless they believe actual evidence exists supporting those disputes. And here we see the judge actually writes verbatim here that the court finds that there are genuine issues of material fact in dispute as to the following.
There it is right there. A, whether defendants knew of the fight challenge being posted by Wesley Watson.
And again, that phrase there is incredibly important. Genuine issues of material fact. So when we translate that, when they say genuine issues of material fact, here the court is saying the court believes a reasonable jury could potentially side with the plaintiff based on the evidence presented at this stage alone. And then the judge here, interesting enough, goes even further. And the judge starts listing reasons, one after another here. And we'll get into exactly some of those reasons listed by the court. All right, notable part here reads, whether the defendants knew of the fight challenge being posted by defendant Wesley Watson. So that's not great, because now the issue is no longer simply, did a fight happen? The issue becomes whether the gym knew about the alleged public invitations or challenges beforehand. Because again, here, for the gym's purposes, foreseeability is everything. If something is foreseeable, businesses generally and may have duties to prevent it. And now the judge is specifically saying that foreseeability is a jury question.
Again, that part, whether they knew about the challenge, I think the plaintiff The victim in this case, I think that's going to be easy for him. Part B, whether the defendants knew of the alleged prior violent history of Wesley Watson and or defendant Nicholas Dellis. I don't know if they knew about Nick, but Wes doesn't shut up. And I'm sure he was in there telling war stories to anybody that was willing to listen. More than likely they were made up, but he would have let them know he was a violent dude, and we've seen in the videos he'll duct tape a whole family. The videos he's made and the things he said, they're gonna hurt him.
Which means that this case is very much alive. And unfortunately for the defense, courts generally do not love the legal strategy of, yes, Your Honor, our influencer may have publicly invited conflict at the gym, but respectfully, we thought it would build community. We're going to get into probably the worst part for Wes Watson here. So the prior violence and reputation. So we see here on the order, it says whether the defendants, again, here the defendants specifically are the gym, knew of the alleged prior violent history of Wesley Watson and or defendant Nicholas Dellis. So that sentence is brutal from a litigation standpoint, because now prior alleged incidents become relevant. And guys, I want you to really notice the wording carefully. Prior violent history. So the court here is acknowledging that there is at least enough evidence for a jury to potentially consider whether the defendants, again, the gym here, knew about the prior violent conduct. And once prior conduct enters the case, plaintiffs' attorneys become very dangerous, because now they're no longer arguing this was some isolated freak accidents. Now they can argue pattern, notice, most importantly, foreseeability.
I don't want to get too far into this man's. You guys know I'm gonna leave some meat on the bone for you guys to go over there, but now we know it's a man, Honorable Antonio Arzola. Wow, and I didn't know. The parties are reminded that this matter is set for trial on May 26th. Now, to me, it's obvious why Wes Watson's attorneys didn't file for summary judgment. There's no point. I wonder, the attorney would know. I would assume the answer is no, but I was going to say, I wonder if they've offered a settlement. I mean, to me, the plaintiff wouldn't want it regardless, right? And, you know, anybody that knows anything about civil litigation, these lawsuits, the compensatory damages are going to be what they're going to be. It's the punitive damages that are going to hurt Wes and Elevation Fitness. Elevation Fitness, I guess maybe they thought, they believed Wes was that dude and everybody would be afraid of him and nobody would pull up. And so if they were aware of the challenge or the challenges put out by Wes, if they were aware, then that would mean that they accepted that risk for the promotion, maybe. I don't know. I mean, I think that even though Wes and his friends all drove these expensive cars, the membership still cost the same, right? So I don't know. But May 26th, if that holds up, May 26th, that trial right there is going to have a huge impact on the criminal trial. Wes is going to have to take the stand, defend himself. And the attorneys for the plaintiff are going to be able to set that guy off in so many different ways. And I know Elevation Fitness is going to be sitting there pulling their hair out of their head. Let this be a lesson for other businesses. Anyhow, that's my video for today. Hopefully you guys enjoyed it. Everybody, please be safe, be smart, and tell the ones you love that you love them, man. I'm out of here.